Good evening, everyone. I, Saquib Rahman, Senior Lecturer at the Department of Law, North-South University, would like to welcome you all to our webinar today. It would be a pleasure on our part to be able to listen to Professor Andrea Bianchi, who has very kindly made the time to talk on treaty interpretation in theory and practice. Before we request Professor Andrea Bianchi to start, I would like to bring to the notice of the listeners that the chat box is open and that they may address any questions there in the box. The audience is requested to please keep their microphones off at all times. And lastly, I would like to extend my thanks on behalf of the Department of Law to all of you present here today. Now, regarding our guest speaker, Andrea Bianchi is a full professor of international law at the Graduate Institute of International and Development Studies in Geneva since 2002. Previously, he was a full professor at the Catholic University of Milan, an associate professor at the University of Parma, and professorial lecturer at the Johns Hopkins SAIS Bologna Center. Professor Andrea has been a visiting professor at King's College London, Hebrew University Jerusalem, the University of Vienna, Faculty of Law, the Catholic University in Milan, and the University of Paris. He has consulted for international organizations on matters related to security and human rights. He has advised for multinational corporations on business and human rights issues, and for states and private parties in international investment arbitration. In 2015, he appeared as counsel for the European Court of Human Rights Grand Chamber in the Al-Dulimi case. Between 2010 and 2014, he served as the designated member of the World Economic Forum Global Agenda Council on Terrorism. He co-chaired the working group on the use of force that led to the Leiden policy recommendations on counterterrorism and international law in 2010. In 2001, he was among the founders of the European Society of International Law, in which executive council he sat until 2010. Professor Andrea has extensively published journal articles on international law and is the author of several books on international law that were published from Cambridge, Oxford, and other acclaimed publishers. Now, before listening to Professor Andrea, I'd like to request Professor Rizwanul Islam, Chair of the Department of Law at North-South University, for his introductory remarks. Sir.
Thank you, Saquib. Good morning or good afternoon or good evening, dear audience, depending on wherever you are. And of course, many thanks to Professor Bianchi for very kindly accepting our invitation to speak on today's topic. Now, in theory, the interpretation of treaties would appear to be a relatively straightforward matter, or it should be like that if you have a look at the principal instrument, the Vienna Convention on the Law of Treaties. It would be about using Articles 31 and 32. However, as Professor Bianchi has very eloquently, very powerfully, and I would say in a thought-provoking way, he has shown that these articles provide for many options. And as he has used the analogy of board game, that these treaty interpretations have many strands in it, has many considerations in it. And not only that, he has also very nicely and eloquently challenged some myths about interpretation of treaties, that we often take words to be granted. We think that we know the right meaning of words, that words are value neutral, words are straightforward. But as by relying on some texts and cases, he has shown that words are not always context neutral, or words are not straightforward. For example, as he has very nicely shown, that the word mother may apparently be only open to one meaning. But even depending on the context of a case of a particular scenario, mother can actually refer to the spouse. If everyone is, but in that particular household, accustomed to the use of word mother as the spouse of the writer of that document. And he has also shown, in my understanding through his works, that the meanings are not always that rigid or that open. It would always be open to various sorts of games and interplay between various actors. So I very much am eager to see how he uh, delivers his lecture today, how he shows the gap between theory and practice in the game of treaty interpretation in international law. Thank you, Professor Bianchi, once again. And I also look forward to the questions from the audience. Thank you all.
Thank you very much, Professor. Professor Bianchi, whenever you're ready.
Well, thank you very much, both Dr. Rahman and Professor Islam, for your kind introductions. And I'm very pleased and honored for this invitation from North to South University and to get to know you virtually online. So thank you so much for having me. I think that given the many years I have behind me in terms of career and in terms of age, I should have learned at least a lesson. And the lesson is that you shouldn't accept to be talking about things that you have long worked on, because paradoxically, but that's one of the most difficult things to do, you don't really know how to squeeze everything you think you have thought about in 30 minutes. So you end up spending a lot of time reflecting about what is more appropriate to say, depending on the audience, depending on those who have invited you, on their expectation, on your knowledge, on your expertise, and then you come up with almost nothing. But the almost nothing, I thought, might be turned into something which I would like to share with you. And what I would like to share with you is the defining moments in which I have come to think about treaty interpretation. Moments that have been triggered by very heterogeneous, quite haphazard events, but that have shaped profoundly my sensibility to the issue of interpretation. I have a very traditional black letter law positivistic background. So as an international lawyer, I had come to believe that key to the success of any interpretive enterprise is the way in which we master the Vienna Convention rules on treaty interpretation, which we know almost by heart. Treaty must be interpreted in good faith according to the ordinary meaning, to be given to the terms in their context, taking into account the objects and purpose of the treaty. And that's all there is. If you are a good lawyer, you know the rules, you apply the rules, and you get to the meaning. So it's both the conviction and the deeply grounded belief that interpretation is about rules, and that those rules can be conveniently found in an instrument, which is the Vienna Convention, which codifies what everybody believes to be declaratory of customary international law. So it seems like a fairly easy task to be interpreting legal texts if you are an international lawyer. But then all of a sudden, I found all these things deeply unsatisfactory. And I think that the one event that probably triggered my initial interest in calling into question these well-established and long-established paradigms was the use that had been done of certain fundamental notions like ordinary meaning or plain meaning. This is a well-known rule of statutory construction, also in domestic legal systems, in certain given context. And I think one of the things that struck me most, besides the anecdote that was already mentioned by Professor Islam, which makes reference to an example which I think is drawn from Lord McNair's The Law Treaties in the early 1960s, in which tackling the issue of plain meaning, the example is made of this gentleman who died and left everything to mother. And as Professor Islam said, one would be tempted to think that there is only one person whom you can call mother in your life. And yet everybody in the household was referring to the deceased's wife as mother. So you see that, the meaning of a word, the meaning of a term is not some sort of essence that is contained in the word itself, but its meaning depends very much in the social context in which it is used, or in the purpose you want to attain. And I think one of the most shocking things that I probably experienced was when I was dealing with issues of terrorism and counterterrorism laws and policies, and I came across the Bybee memos, named after one Mr. Bybee, legal advisor at the Office of the Legal Counsel at the US Department of Justice, which you must know is a very important office because their interpretation of the law is binding on the whole of the US administration. So the stances they take on how to interpret law are very important. And the office had been called upon to interpret the notion of torture in the context of so-called enhanced interrogation techniques. And particularly, the issue was how the notion of torture under the 1984 UN Convention, incorporated into Section 2340, if I'm not mistaken, and 2340A of Title 18 of the United States Code, had to be interpreted. Because in that particular provision, torture is defined as an act that causes severe physical or mental pain or suffering. And to make a long story short, at the Office of the Legal Counsel, they got to a definition of torture, which is quite disconcerting, but one which is justified on the notion of plain meaning. So if torture, according to the Office of the Legal Counsel, has to be qualified as a particularly severe physical or mental pain or suffering, well, let's look at other statutes in which the same expression is used. And they ended up, surely not by chance, to the statute that determines emergency medical conditions. When you go to the emergencies into the hospital, you are given a different code depending on the gravity and the severity of your condition. And in that statute, the relevant provision, severe, was defined as damage that rises, and I quote, to the level of death, organ failure, or the permanent impairment of a significant body function. End of quotation. So whatever falls short of that threshold of severe damage to health, that is death, organ failure, or the permanent impairment of a significant body function, is not torture, as it's not sufficiently severe. Now, I think this is an interpretation that shocks the conscience of many reasonable persons. But what shocked me most was that the justification for that interpretation was found in the ordinary meaning of the words. Severe mental or physical pain or suffering. And then that's the first defining moment in which I set out to see how interpretation is done in other disciplines, and how can one make of interpretation if we are ready to go beyond the rules and the rules of interpretation as we know them in the Vienna Convention. And then I discovered a whole universe out there. First of all, I discovered that interpretation is surely not an activity that only concerns lawyers. We interpret every day events, things that we read, situations alike, and that there is a lot to learn which is not somewhat related to the rules of the Vienna Convention. And it is in that particular context that I found, for instance, that the idea of plain meaning, of ordinary meaning, is not necessarily to be thought in connection of some quintessential element, which is present in the text that the good lawyer knows how to extract, how to pull out. And it was the work of linguists in particular that made me cognizant or made me aware of this. And I think the example that is very effective is when you utter a very simple statement like the boy chased the dog with the car. And what you visualize immediately is clearly a boy driving a car and chasing a dog, not the other way around. But there is absolutely nothing in the structure and grammatical structure of the sentence that tells you that it should be the boy driving the car and chasing the dog. It could be the other way around. But it is a plain, ordinary meaning, not because of some quintessential thing that exists in the words or in the expression, but because of what we know of the context of what we know of boys and of dogs. So that was a very striking moment when I realized that after all, our obsession with textualism and with the ordinary meaning and with the fact that if we are good lawyers and we know the rules, we get to the meaning was shaken. And ever since, I found interesting and particularly intriguing, even if I am a lawyer, even if I am an international lawyer, to think of interpretation as a much more complex process, which is not so much dependent on rules, but on context and social circumstances, because the meaning of words, the meaning of certain expressions is given, as Wittgenstein clearly said, by the practice of a certain community, by the context. You remember the example of mother. Mother was not the biological mother, but simply the one which everybody in the household referred to a certain person. And I think that's a very useful starting point to call into question this deeply ingrained notion that we have about rules determining the meaning of things. In fact, interpretation is a much more complex process, which involves cognitive idealized models that we have in our head, the way we function, the way we interpret things, we think about things in a given culture. There are other fun examples one might use, but if you try out against a crowd of people, against an audience, and you ask who's a bachelor between the Pope, Tarzan, and James Bond, you might 9 times out of 10 get the response, the immediate response from the gut, James Bond is the bachelor. In fact, also Tarzan, before meeting Jane Hubs, and the Pope are not married for other reasons, but in our idealized cognitive model, the figure of James Bond fits better, and that's why we tend to associate directly James Bond rather than the Pope or Tarzan with the condition of a bachelor. But I think these incursions in other fields, in other disciplines, in which the issue of interpretation is discussed more freely, was conducive, at least to me, to a better understanding of the process of interpretation. The second defining moment, or the second shift in my thinking about interpretation, which gave rise also to the book of interpretation in international law, is when I started thinking of interpretation as a game. And again, sometimes intuitions or things that triggers certain process of intellectual curiosity, why you start all of a sudden studying certain things or looking at certain things in a given way, depends on very contingent factors. I had been invited by the University of Cambridge, in fact, by 2 PhD students, to give a lecture on interpretation, pretty much the occasion we have today. And I had accepted, and I had taken that as a pretext just to formalize an idea that I had long playing with in my mind, that one could productively think of treaty interpretation as a game. And then I went there. I realized only when I arrived on site that I was to be the keynote speaker of a huge conference. And I remember that James Crawford gave me the floor, and I was to speak for about 30 minutes. At 20 minutes, I think he got sufficiently shocked he wanted to take the floor back. But that's another story. But there I presented this idea that interpretation could be seen as a game. And then, I went back home. I was prepared to send what I'd written to a journal for publication. And then these two PhD students at Cambridge University called me up, and they proposed to edit a book together, which we did. And it was a great experience, which was published as Interpretation in International Law. And this metaphor of the game provides the overarching structure of the book. The book, which doesn't tell you how to interpret, but it does provide insight on what type of activity interpretation of treaties is. And so I would like to spend the next 10 minutes perhaps quickly revisiting or reviewing some of the fundamental ideas behind this, because I think it is potentially a fairly useful way of thinking what we do when we do interpret a treaty. And the idea of resorting to metaphors, I think, is something that is very dear to me. Metaphors are powerful tools of mediating knowledge that help us a great deal when we want to understand reality better, particularly when they provide mental links and associations to objects or situations that we experience in our daily life. And we're all familiar with games. And games, contrary to what most lawyers might think, are no ludicrous thing, nothing that you should laugh about. Games, board games are part and parcel of the very foundations of cultures, just as music, dance, literature, or other common activities that shape up the identity and social practices of all communities. So when I say that interpretation is a game, it's not because I want to make a mockery of the activity of interpretation, but simply because I wanted to describe very seriously a practice we undertake practically on a daily basis. And why the metaphor of the game? Because I thought that this might help us going beyond the idea of the rules and of the rules of the Vienna Convention and that, and help understanding better what the stakes are, who the players are, what are the rules, not in a technical way, but in a much broader way. What is the context of the game being played? And then also the meta level. Why is it that we are willing to play the game, and what does the game of game playing, but forgive me, my pun, is about? But let's think for a second. I think there are some threads of thought that might be interesting. Why a game? A game has definitely a purpose, has a goal, and the goal is to win. And I think this is also a very powerful metaphor, because also when you interpret, you tend to be willing to win. And to win in the context of interpretation, depending exactly on where you are, you may be before a judge, you may be before an audience of scholars because you have written a book or an article, you may be trying to convince the Minister of Foreign Affairs of doing this or that on the basis of Article X or Y of this or that treaty, but there is always a context in which you try and persuade somebody. And I think the idea that the game is about who wins is about who succeeds in persuading that his or her interpretation is the right one, is the more fitting one. Of course, these parts company with the positivistic idea that there is only one correct legal view, and that if you are a good lawyer, you are supposed to spot the right answer by applying the rules of interpretation. I obviously take issue with that view. I think that law is about persuasion. Interpretation is about succeeding in persuading an audience of what the right or correct interpretation is. And that gives a precise focus of the interpretive activity because it provides an object to the whole game. And this is something that we don't necessarily take into account, but once you enter into the metaphor, once you realize that indeed it may be a matter of winning by persuading, by convincing, well, then you realize also that the means of persuasion, that the means of convincing that a certain interpretation should prevail over other, is also a matter of technique, is also a matter of skills, and it's also a matter of mastering the context in which you argue, and of mastering also some well-known technique like rhetoric, which is an art which has been vilified for centuries in the West, at least after the Enlightenment, because it is associated with empty, rather shallow instruments of language transmission or oral expression, but in fact, it's an ancient art, highly dignified, which provides you with tools to make your argument more persuasive. And then the second element in the metaphor of the game that I think is very useful, also from the perspective of the practitioner, because the practitioner, the skilled practitioner, the good practitioner, is somebody who is perfectly aware of the context in which he or she has to argue. And the players are also important in the game, and identify who the players are. And who are the players of the game of treaty interpretation and international law? Well, there might be some obvious players, some of the usual suspects, the states, the international organizations, and so on and so forth, what we call the subjects. But in fact, the game is much more open to players than the formalistic doctrine of the subjects of international law allow. In fact, anyone can try and persuade, can put forward an interpretive argument to show that this or that interpretation of the treaty is the right one. And this calls, of course, on lawyers, international lawyers, practitioners, government lawyers, scholars and academics who are tremendously powerful because of the influence that they can wield on these matters. I think your invitation is evidence of this. And most of all, may I say so, judges, because let's admit it, we international lawyers, even more than our domestic law brothers, we are obsessed with judges and with judicial determinations. We think that the truth about the law is usually uttered by judges. The judges provide the authoritative interpretations of how the law should be interpreted. Now, there might be very obvious reasons for the importance that we attribute to judicial determinations in international law. It has to do with our inferiority complex towards domestic legal system. It has to do with the fact that we have no central lawmaker that can, utter the words of the law in an impartial and neutral way. So we just make it up by attributing that same function to judges. But all these different players that can play the game of the interpretation, they do not have the same or an equal weight. As we all know, there is a huge difference depending on the authority which is associated with the different players of the game. There are some institutions that are perceived to be particularly prestigious. It depends on where you are. If you are in general in public international law and you are a generalist, when you say the court, you refer to the International Court of Justice. If you are a human rights advocate or lawyer or academic in the West and in Europe, when you say the court, you usually refer to the Strasbourg Court, the European Court of Human Rights. Every community has got their own specific authoritative forms or expression of authority that provide interpretation of the law that are particularly important and that have a particular authority in certain communities. And the same considerations apply also to academics. Academics have different reputation, depends on where to teach and who they are, on the practice they have, Probably, the word of the chair of International Law School is regrettably, but that's how the world goes, more authoritative than the word of a colleague who's perhaps 10 times more brilliant, but who happens to teach, I don't know, in a university in the south of Italy. No offense as meant by this comment, but I think all these mechanisms are not well accepted and are not unearthed by international legal scholarship, and yet they are so important. They are so important because they can let you better understand how the process of interpretation is also a matter of the authority of the players. It depends who the players are. It depends, once again, on the context. It depends on the authority which in the profession we attribute to this or that particular player. Then just a couple of words on the cards. The cards are primarily, the criteria that we as international lawyers are used to play with, not just those in the general rule of interpretation of Article 31 of the Vienna Convention, not just ordinary meaning, object and purpose, but there is plenty of other cards that we can play. We can play lex specialis, we can play other rules, and depending on who you are before, you would definitely play a certain set of cards. If you are before the European Court of Human Rights, you can speak about the treaty, the convention as being a living instrument. You would go absolutely nowhere with this argument if you were to argue before the International Court of Justice. So the cards are highly contextual. So are strategies that can be employed or put to good use, depending on where you are, depending on which context, which social context you operate in. There are some strategies that are particularly dear to lawyers. Usually we praise consistency, predictability. So the more a certain interpretation of a treaty provision is provided with an aura of certainty and predictability for the future, the better. Or the idea that a general rule or a residual rule should be applied if no exception applies. This is how the law of state immunity has developed over time, and so on and so forth. But this is just, the flavor of how a metaphor, which has nothing to do whatsoever with interpretation, might be put to good use in order to understand some of the processes that are at play when we do interpretation or we do treaty interpretation. Now, as I am approaching the end of this 30 minutes that we had set for this seminar, let me just draw a couple of conclusions that I hope might be of some use to some of you. I think that what I wanted to get across is the message that interpretation and treaty interpretation is primarily a practice. And as a practice, it is not defined by rules. If you are interested in this distinction, I think it's jolly good to read an article of a philosopher named Hubert Schweitzer entitled Rules and Practices, in which Schweitzer takes issue with John Searle, who had said that the game of chess is defined by its own rules. And Hubert Schweitzer counters that statement with a hypothetical example. And he says, suppose that there is a country which is called Ruritania, and that in Ruritania, once a year, people assemble around a huge, big chessboard, where you've got the pieces, the pawns, the queen, the king, and where the queen moves freely across the chessboard, like in the rules of chess, where the rook moves vertically and horizontally, and where you've got these people who move these big pieces exactly in the same way which the rules of chess dictate. And yet, this is no game. This is just a sacred rite that priests carry out every once or twice a year to find out what the will of the gods is. And the inference to be drawn from this is powerful. What matters is not the rules that we associate with the game of chess. What matters is the meaning of the social practice. What matters is what people take what happens on the chessboard to mean. And in Ruritania, that practice has a clear meaning. And that meaning is that the god of the wills has to be figured out by moving these pieces and by letting priests interpret what's going on. So the rules of the practice do not tell us what the practice is. So by paraphrasing that, may I conclude that the rules of interpretation do not tell us what the meaning of the law is. We have to get there by a much more complex process. And the more we know about that process, and the better lawyers I think we can become. That's why I would like to conclude with an invitation that there is nothing wrong to be curious, open-minded, and imaginative. There is nothing wrong in sticking your nose into other disciplines and see how the process of interpretation is carried out by other people in other contexts, because that is tremendously helpful for our legal practice. There is no need to be ignorant. A good lawyer is not necessarily what Pierre Schlag once defined somewhat nastily as somebody with a stunningly selective sense of curiosity. It doesn't have to be that way. And we must understand that interpretation is a process which is strongly influenced by the context in which it takes place and by the people in whose community the very process takes place. And on this, I will end. I think it's about 31 minutes or 30 minutes. Thank you very much for your attention, and I look forward to taking up your questions, if any. Thank you.
Thank you very much, Professor. We have a lot of questions, and whenever you're ready, I will be conveying the questions to you one by one.
You may go ahead.
Thank you so much, Professor. Here's the first question. So, is the quest for true objectivity in the treaty interpretation going to be a futile one?
Short question. Short answer, yes. Yes, and I'm sorry to disappoint most of the audience in saying that. I know that I will, but that's what I've come to believe. Yes, what we should be seeking is not any objective truth, but there is some truth in the accepted social meaning of something. Yeah, if you want to call it truth or objective thing, fine, but it's not what we have come to associate with the objective view of the correct legal view in a positivistic sense. If that is the question, then the short answer is no. Yes, I do believe that's futile. And this was the vision of Sir Gerald Fitzmaurice, both as a scholar and as a distinguished member of the International Bench. For him, the good lawyer was the one who was able to, and the good judge also in the exercise of the judicial function. So Gerald Fitzmaurice said the judge is the one who's capable of providing the correct legal view, the correct legal interpretation. And Lauterpacht, pretty much at the same time, had a completely different vision. He said, judges, whenever they come up with an interpretation of the law, they have to take a choice, to make a choice. So they always make a choice when they decide the law ought to be interpreted in this or that way. And most of the time, their task is very difficult because it's not the choice between a completely unfounded legal argument and a good one, but between two or even more equally plausible legal argumentation. So what you end up doing is choosing. So what you should be looking for is not the objective or the neutral interpretation of the law, but the most persuasive in the context and in the circumstances.
Thank you very much, Professor. Here's your second question. How would you evaluate the role of the ICJ as the interpreter of treaties?
Yeah, I mean, as I said during the presentation, I think that the ICJ has a particular prestige in the world of public international law. So it's a particularly powerful player because of its history, because of its role, because of the fixation that we public international lawyers have with judicial determinations. So whatever the ICJ says, it's going to be authoritative. Yet, like any other tribunal, the ICJ, regardless of the authority it enjoys, must be persuasive. And I think one can easily distinguish between good persuasive judgments of the ICJ and not particularly good, not particularly persuasive judgments. I wrote an article which precisely deals with this capacity of the ICJ to structure rhetorically convincing arguments, despite of the outcome. I am very critical about the outcome on the relationship between state immunity and human rights in the jurisdictional immunities of the state case between Germany and Italy. But rhetorically, it's a very well constructed judgment. One that once you read it, once you go through it, you are fairly persuaded that this is, the decision that the court had to make. But it doesn't have to do with the merit, with the substance. It has to do with the way in which the argument is laid down. Contrary to what the same court did in arrest warrant, when it was a matter of determining the jurisdictional immunities of the former foreign minister of a state against instigation to genocide. And regardless of the outcome, but this is a poorly reasoned and little convincing judgment. So my point is, there may be very powerful actors when it comes to treaty interpretation or to the interpretation of international law altogether, like the ICJ in the field of public international law. But the ICJ, like any other speaker, must be convincing when it talks to an audience. And tribunals and courts do have audiences. And nowadays more than in the past, because in the past they might be addressing as an audience states, courts, foreign ministries, but nowadays sometimes they have an audience which reaches out to world public opinion. So I think they are very concerned about being convincing and persuasive of their choices.
Thank you very much, Professor. Here's the third question. In interpreting treaties, do the judges in international courts and tribunals have a greater latitude than the judges of the national courts in interpreting statutes?
I don't know. I don't know. It's hard to compare because in every jurisdiction, domestic jurisdiction, there are different traditions of rules of statutory construction, which more or less compelling. So it's difficult to compare. But I think that either way, whether you are a domestic law judge or a judge in any international tribunal, your latitude of discretion is always there because it's you who decide which interpretation to attribute to a given word in a statute or an expression, to have recourse to a presumption, or to have recourse to a general rule, exception, paradigm to frame a certain case. It depends very much on how you frame a case, for instance. And this will give the audience the impression that, your choices was compelled by the fact that, I don't know, there was this presumption, which obvious outcome is this, but it's still the judge that makes the construction. And it's also, in my view, a matter of being convincing and persuasive.
Thank you very much, Professor. Here's the fourth question. In the treaty interpretation game, do transnational companies play any role?
Oh yeah, definitely. Oh yeah, definitely. That's why the notion of players is not coextensive with the subjects of international law. So it depends. I mean, national international corporations clearly have a say in international lawmaking processes, in treaty interpretation. Their role is limited to the fields of international law in which they have interest, in which they have a voice. Their voice can be heard. But certainly they have been very active in playing the game of interpretation in the business and human rights field, for instance. So the answer is definitely yes. But there is no answer which is valid once and for all, one size fits all kind of argument. It depends in which particular context you are located, because the players may change in their role in terms of authority, interpretive authority, and semantic authorities may vary. But surely also international corporations' voices can be heard, and they can be quite persuasive. Yes, definitely.
Thank you very much, Professor. This question comes from someone called Antara Labiba. She asks, how can the interpretation be made more diverse, given that academia, by default, is inaccessible to a large portion of people?
By what we are doing today, for example. Yeah, I mean, I say that it's very difficult to change the world, to change legal mindsets, to change established practices, to go against tradition. I can tell you most of the time it's close to impossible, and it may get very nasty and very unpleasant. I know out of personal experience. I've been lynched by many crowds delivering provocative or critical speeches. But I still believe that things can be changed in a very humble way by calling certain axioms into question, by exercising critical judgment, by being more aware, more critical-minded lawyers. So I do agree that academia is usually traditional, that law faculties and law schools are the most traditionals among disciplinary departments. But I think that, you know, regular doses of critical thinking might help change the situation. And don't you ever underestimate change in your own self. You will be a professional, so you will have to make choices. And I think that, you know, perhaps it's too short, a shot to change the whole world, but you may change it in your own little way. So not to be underestimated. And another element, which I think is fundamental in this reflection, is that university classrooms are the places in which revolutions can be made, revolutions in the mind, at least, which can be very powerful.
Thank you very much, Professor. That gives us a lot of hope for those of us who are law professors or lecturers. Thank you very much. Here's your sixth question, Professor. How would you evaluate the role of the amicus curiae briefs in the treaty interpretation game?
Yeah, again, depending on context and depending on the quality of the amicus curiae brief. I think it can be very influential in some jurisdictions. It depends on who submits it. It depends on the credibility of the player as well. But it's a fact that, you know, the European Court of Human Rights has extensively and repeatedly had recourse to reports of human rights organizations to establish the human rights situations in certain countries for the purposes of extradition or renditions. You know, there are some jurisdictions that are culturally less prone to amicus curiae than others, and it's a matter of socialization and acculturation. It takes time, but it's also something that has to do with quality. I have seen cases in which, you know, poor quality submissions are made, and that doesn't help the courts of amicus curiae. You know, in order to be credible, like for NGOs, professional associations, or any other of amici curiae, you've got to be credible. And again, but you're playing the same game. The game is persuasion. And in order to persuade, you need to be credible. So, you know, that reinforces my point, but it might be my bias, that, you know, it's all about persuasion. So if you are an amicus curiae who has good skills and, you know, you may be influential in before certain international courts and tribunals, yes.
Thank you very much, Professor. Here is another question for you. How can scholars in the global south be more active in the treaty interpretation game?
Well, the issue is having their voices heard and recognized. But again, it's not just in the treaty interpretation game, but it's in the game with international law, because you could use the same metaphor precisely, exactly for the same purposes. You can use the metaphor to apply to international law altogether. So by trying to have their voices heard, by trying to, it's difficult, I know, and there is plenty of complex issues. Also, those coming from the South who've been educated in Western universities, sometimes they are accused of not being legitimate representatives of the global South. So it's a complex discussion, but there are people who are committed to listening. So I hope that you will be able to bump into some of these people. That would facilitate greatly the task.
Thank you very much, Professor. Here's question 8. After all, treaties are all about applying the agreed rules to contentious situations. So what justice in this treaty interpretation, what justice is there in this treaty interpretation game?
Well, that's a difficult one to take, because it may very well be that the treaty was agreed by some parties at a given time. It's difficult to see how the parties can keep control of their treaty. It's like when in literary criticism, you speak about the death of the author, meaning that once you lay your text on paper, you must die, because then the text doesn't belong to you anymore. It belongs to the readers. This is a bit of a provocation, but it's difficult, or it's too simplistic to say that your priority should simply be to seek for the intention of the parties at the time of conclusion, which you may very well need to argue in certain contexts, because that's your interest and that's game you need to win. But I think there are other factors that make the fair application of the treaty a fair process. Not just the preservation, sometimes of the treaty made decades ago, and in which the will of the parties is very difficult to be reconstructed outside of, there is no travaux préparatoire, or circumstances may have radically changed. You will always find one of the parties trying to argue for an interpretation based on the will of the parties at the time of conclusion. It's a slightly more complex process. In fact, the truth is that interpretation is a decision which is taken at a given time. If it's a court rendering a decision, that's the moment in which justice or injustice is being done. But I think justice or injustice, it all boils down by who's been most effective in arguing what they have argued.
Thank you very much, Professor. Here's your next question. How would you draw a line between the treaty interpretation and making a treaty in the name of interpretation?
I don't. It's one and the same thing. By interpreting, you make. Positivists don't like the concept, and we have been trained since we were young lawyers that never ever should interpretation be allowed to replace the will of the lawmaker. But it's a fiction as many others. Anytime we interpret the law, we take a choice, or we make a choice that determines the content of the law, and therefore, like it or not, what you do is to make law. So I wouldn't draw. I don't think it would be. It might be traumatic to some people if you draw a line, because you might yourself been overstepping the line many times.
Thank you very much, Professor. Next question. Most of the players are taught in law schools. How does the teaching in the law school play a role in the game of treaty interpretation? Could you please elaborate a little bit more?
Yes, fundamental, absolutely fundamental. And I said earlier that I think that university classrooms are the places in which people can be taught to think independently and to think critically about things. and to be told the truth about the fact that whenever one is called upon professionally to make an interpretation, they will be making a decision. So they should do so responsibly and with a sense of appropriateness and responsibility according to their functions. So I think there is nothing diminishing in saying that we are empowered as lawyers. We have the power of making important decisions. We can't hide behind the screen of the law, which is something else. No, we make the law, we say the law, depending on what personal and professional capacity you will operate, but you will be making important decisions if you are in government, if you are in the judiciary, or if you are in the university classroom, because the professor in the university classroom has an incredible authority. Most of the default settings, as I like to call them, that we have as professionals, as lawyers, we develop them in the very first formative years of law school. So all the teachings about, I don't know, the distinction between law and politics that should never come across each other, the idea that the judge can only apply the law but can never make, certain default setting reflexes are formed at the level of the law school. And that's why it is dramatically important that university instructors, at least some voices are critical, just to open people's eyes to what law is about. Law is a social process, and it has to be administered by human beings. So it has to be taken seriously, but as a human endeavor. And I think one of the tricks that we often resort to is that by presenting ourselves, by representing ourselves professionally as those instruments of the law, we act as priests of a religion. We are the intermediary between the law and the people, just like the priest is the intermediary between God and the people. And it's a very empowering situation. And lawyers like power, and to conceive of law in this way makes them powerful. So it's not a particularly powerful or popular thing to do, to tell people this, because that takes away a little bit of the aura of power. So I hope that you have some instructors in your curriculum that think differently or present to you things slightly differently. And then I hope you will develop your own capacity to make your personal choices between what you have listened to.
Professor, thank you very, very much. We are almost at the end of today's lecture. Thank you very, very much for making time, and I thank everyone present here today. And I must say, Professor, we've actually had a very good number of people listening to you. And for those of you who might have missed any part of our professor's talk, this particular video will be uploaded in our YouTube channel. Thank you very much, Professor. Thank you very, very much. And we hope to once again get hold of you for another interesting talk.
It will be a great pleasure. Thank you for having me.
Thank you very much.